Hello and welcome. Today we are going to be talking about 7 tips for creating amazing contracts. Now, I know this is going to be, I've been beating on this drum for a while, but I can't stress this enough. Contracts are like the foundation upon which good businesses do business. And the reason for it, and we'll talk about this in a lot more detail, is that a good contract will save your business from potential financial ruin. It'll save your business from litigation. It'll save your business from so many things. I cannot stress the importance of having a good contract. A lot of small businesses, I just think that they're not as necessary or as important as that they really are. And I can't stress enough how important they are. In law, in this case, an ounce of prevention is worth a pound of cure. It is so important that you have a good contract, and avoiding boilerplate contracts. Those are not worth the paper that they're printed on for the most part. They're very rare exceptions because they don't encapsulate. They give you a false sense of protection is what it really comes down to. They don't typically encapsulate the entirety of the agreement adequately, and so you're left vulnerable to things that you shouldn't be if you have a good contract. I can tell you right now, a good contract will save you thousands of dollars, tens of thousands, maybe even hundreds of thousands of dollars, depending on your business, if you have good contracts in place to protect you and to protect your business from potential issues. If you're new here, my name is Taylor Darcy from Think Legal, where I help you create the business of your dreams. So welcome. I'm excited that you're here. We go live every weekday except for holidays, Monday through Friday at 11 a.m. on the dot. And we really dive into the important issues that you face as a business owner. I want you to feel like the confidant, someone that you can rely on, a trusted advisor, if you will, to make sure that you're getting the legal help that you need. And we're going to talk about lots of different things. There are so many topics that a lot of businesses are losing out on because they can't afford an attorney. And so my solution was to become working with businesses that are on YouTube in order to give you the help that you need. Now, as I said in my disclaimer, you want to make sure that if it's something specific that you talk to an attorney in your local area, because there are differences in laws and there are differences in how you want to go about things. So when you're looking for specific advice, please consult your local attorney to make sure that you're getting the right advice for your situation. If you need help and you're in California, I am happy to discuss your matter with you. There are links to scheduling appointments down below. So please make sure you're using that if you'd like to discuss with me further. Number one thing, you want to make sure that you have the legal names of all the parties, and that includes the business. If they're doing business as a DBA, you want to make sure the DBA is included. You want to make sure everybody's title is included. You want to make sure the address is there, where the business is from. So if they're in a California business, that needs to be stated as a California limited liability company, or if it's a corporation, the appropriate titles of that. If it's Delaware, whatever it is, in order to make sure that it's clear who those parties are and under what circumstances they have entered into this contract. First and foremost, you want to have all the legal parties of everybody's name. Agreements are between the correct people. That's number one. Next thing that you want to have are clear and definite terms. And this is where your magic is. This is where your minutia, you need to pay somebody. You really do, to look at the details of your business and make sure that you are being protected adequately in the minutia. Because here's the thing. If you don't do the minutia, the contract can be void because of its vagueness. Anything that you can put in that contract to make it clear of what the expectations are of the parties is going to help you and the other party, right? It's going to help you so that clear expectations are managed and you've already discussed them. And so there's no issue that can't be resolved before it. Look at it as when you're in a honeymoon, you'll agree to almost anything. I mean, a contract is like a business prenup in the respect between those two parties. People will agree to things when they're looking at getting into business with somebody, but once they're in business with them, they might not agree to those same terms. And so you want to make sure you're doing this before you enter into any type of deal so that you're making sure that you're protected in that one. You want to make sure that your attorney or whoever's drafting it or yourself includes all of the correct relevant clauses, because those all have a very important role in each contract. You want to make sure you're having your choice of forum clause, your choice of laws, any type of waiver clauses. There's some boilerplate that is good. It's just that the most of the contracts that you get off of the internet are too boilerplate. They're not specific enough for you, and they can fail for that reason. The next thing you want to make sure everybody signs. If someone doesn't sign, they're technically not bound by that contract, and that can have far-reaching consequences. So you want to make sure that everybody signs it and it doesn't have to be difficult. It doesn't have to be hard to do. You can use electronic signatures through DocuSign, HelloSign. There's a lot of electronic sign companies out there, Adobe Sign. And you want to make sure that everybody gets a copy and that everybody signs in their names, and that there's even language in the contract that talks about counterparts. So not everybody has to have a fully executed copy. Ideally, that's what you want to have happen. But if you sign it, they sign it, and they're counterparts, and you put the two together and they equal a signed copy, then you're okay too, for the most part, as long as that's included in your contract. But signatures are very important to make sure that everybody's playing by the same rules and everybody's bound by the same thing. Next thing that you want to remember and to make sure is that you're following what's called the parole evidence rule. And the parole evidence rule is a fairly simple, I'm going to simplify it quite easily. If it's not in the contract, it doesn't exist. Everything that you want to be in that contract needs to be memorialized in the contract. You need to make sure that you're not putting something in there that you don't want, or that you're putting stuff in there, forgetting to put stuff in there that you do want. Those are all very important, crucial details, and this is part of the clear and definite terms. But just know that under the parole evidence rule, if it's not in the four corners of the page in the contract, then you can't be held to it, unless there's certain circumstances, in which case that there's vagueness or if there's fraud, but those are all the exception and not the rule. The next thing that you want to do is keep in mind that if it goes without saying, if it's implied, that it usually goes better with saying. And one of my law professors used to say this, and it was just it stuck with me for all these years because of how important that is. This is about, if it's important to you and it's keeping you awake at night, you really want to make sure that you're putting that in the contract and having it very clear that it's important to you. So don't leave a contract just because you're afraid of offending the other party about what you want as a term in that contract or condition. And the big reason for that is that if a deal is going to fall apart, you want it to fall apart before it gets to past the contracts phase, not when you've already been executing and doing things that are under the contract and then have it fall apart. Last, number 7, you want to have your remedies. And this is kind of important. I mean, this isn't just kind of important. This is very important. You want to make sure that it's clear in your contract what are remedies that will happen if there's a breach. And the reason for this is that the courts love to see that the contract outlines what the remedies are. That way they don't have to guess. It makes enforcing a contract so much easier for you, and it makes the courts to enforce the contract so much easier for them. By having the proper remedies, and again, these are things that you may not know, and you want to definitely have an attorney to draft these, that the remedies will allow you to get the exact thing that you need, so that if you're harmed, the judge, it doesn't have to go very far. It'll save you a lot of money by having your remedies contract clause very correct and very clear and very up to date. And contracts are something, this is a kind of a bonus tip, if you will. Contracts are something that a lot of businesses, they just kind of sit on, and then they don't update them very regularly, and it ends up hurting them. You want to review your contracts as often as you're doing a new agreement for any, not only just incorrect language, incorrect thing, but also to make sure that nothing has changed. If the law has changed since that contract was drafted, you want to make sure that you're going to get the law correct so that you're getting the best contract possible. And so you really want to stay up to date on those things, or have an attorney that does stay up to date on those things so that you're not having to. I mean, your best use of time should be running the business, not worrying about what's on your contract. That's just the truth. You should be focusing on your business, not worrying about that minutia and those clauses and those terms that we were talking about. If you've gotten value out of this video, please don't forget to hit subscribe and like this video, and also hit the bell icon so you get notified when we go live. And again, I go live every Monday through Friday, 11. Forward to meeting with you. Please feel free to leave any comments or questions that you have below. I'm happy to reach out to you. But again, make sure that you're talking with local counsel so that you're getting the right advice for your situation. And we'll talk to you later. Have a great week, and see you soon.